And welcome back to Noon Edition. Our guest this afternoon is Dr. Bill Angel from Ohio State University Lima. Yeah. We're talking about the Supreme Court, and we have a sticky situation, if you will, because Chief Justice John Roberts has said, I don't think we need any kind of an ethical resolution. Things are running smoothly, kind of has a blind eye toward this whole situation, but we've seen otherwise.
Well, blind eye is a good way to put it, because you know, there are rules for lower court judges and state court judges about conflict of interest. And the court has not been willing to police itself on conflict of interest issues. The normal procedures when there's a conflict of interest, like a financial investment in a company, or you get payments from a lobbyist, you should recuse yourself from deciding on the issue. And that's why the court has not done that at all.
And we've seen recently, former Chief Justice Clarence Thomas has now admitted, yeah, I've taken some perks in the past. That's opened up another can of worms.
Well, these are lots of perks, and it's not just Thomas. There's also a law school down in the Virginia area, George Mason Law School, called the Scalia School of Law. And they basically want to train lawyers in a more conservative viewpoint. And they've invited people like Gorsuch and Kavanaugh and Thomas to do teaching positions at their universities, except it's not on the campus. It's a place like Reykjavik and Verona, Italy, and it's junkets, basically, which they get paid. Gorsuch's flight to Italy was like $6,000, and so it's more like a vacation than it is teaching.
Sure.
And so, but it's caused me to think back. You know, years ago, 55 years ago, 1968, we're in the middle of a presidential election. Chief Justice resigns. Earl Warren resigns. And President Johnson thinks he's going to make a power grab here and appoint his old pal, Abe Fortas, who was an associate justice, onto the position as Chief Justice, and to move one of his other cronies onto the court. It was a power grab. And the court resisted that. I mean, Congress resisted that. I mean, it didn't have a chance of getting Fortas getting seated, but Congress resisted. They stood up to Johnson. And one of the things that was discovered in the course of that inquiry was that Fortas had taken a $20,000 salary to teach at American University, which would be worth about $130,000 today for a 9-week course. It was paid for by a lobbyist. It wasn't paid for by American University. And so, I mean, that sunk his any chance Johnson had of getting that through. So if it was not okay for Fortas, then why is it okay for the current justices to take these trips, these sabbaticals, and all that, and yet take money from lobbyists? Congress has a right to stand up to that. And it's not a conflict of it. It's not a violation of separation of powers doctrines, as some are trying to say. It is basically the right of Congress to say, okay, you won't police yourself. We want to basically establish some minimal rules so at least you can get recusal from cases when there's a conflict of interest.
And this is not a political thing where Republicans or Democrats, both parties should be looking at this evenly.
They should be, except the Republicans, if you listen to that hearing yesterday, are blaming the Democrats for just going after this because they want to make the court look bad because they are conservative judges. And that's not the case at all. Those Republicans ought to be standing with the Democrats because this is something that could come back at a future time and hurt them if, in case of liberal judges trying to do the same thing.
Bill, always a pleasure talking with you. You're a wealth of information.
Okay.
And we will be back as Holly will have medical news coming up next on Noon Edition.